the Dean of Duke Law School, and I'd like to take a moment to welcome you to this year's Robert R. Wilson Distinguished Lecture. The Wilson Lecture is one of several distinguished lectures traditionally hosted by the law school on an annual basis, and I'm delighted that you've joined me for the second of these flagship events for the 2024-25 academic year. No event of this scale can happen without a lot of logistical work behind the scenes. In particular, I want to thank our law school communications, events, and IT teams for supporting the event, and Monica Roberson of the Dean's Office for her work in coordinating Professor Hinton's visit. Robert Renbert Wilson was a professor of political science at Duke University from 1925 to 1975, and this lecture is named for him. Professor Wilson founded and chaired the Department of Political Science, served as Director of Graduate Studies, taught at Duke Law School, and chaired the Commonwealth Studies Center at Duke University. In addition to his service at Duke, he was also an advisor on commercial treaties for the State Department. The Robert R. Wilson Lecture was established by Herman Walker, who was Professor Wilson's student and later his colleague, and was funded in part by the Robert R. Wilson Fund. Previous Wilson lectures have included luminaries such as Evelyn Higginbotham, Mary Dudziak, Paul Finkelman, Adrian Davis, Rebecca J. Scott, Duke's own Thavolia Glimp and Tim Lovelace, both of whom I see are here today, and most recently, Dylan Penningroth. This year's distinguished lecturer is Professor Elizabeth Hinton. Professor Hinton is Professor of History, African American Studies, and Law at Yale University, where her work focuses on poverty, racial inequality, and urban violence in 20th century America. She previously served on the faculty of the Departments of History and African American Studies at Harvard University, and she is the founding co-director of the Institute on Policing, Incarceration, and Public Safety at Harvard's Hutchins Center for African American Research. Professor Hinton is the author of 2 books, From the War on Poverty to the War on Crime, and America on Fire, The Untold History of Police Violence and Black Rebellion Since the 1960s. She is also a contributor of articles and op-eds for a wide range of publications, including the American Historical Review, Science Magazine, The Atlantic, The New York Times, The Boston Review, and Time. She joined us today to discuss racism, law, and the hidden power of the archive. Please join me in welcoming Professor Elizabeth Hinton to Duke Law.
Good afternoon, everyone. Okay, you can hear me okay. I apologize in advance. I've been battling to regain my voice for the past couple of weeks, so it's better than it was a few days ago, but it's still not quite there. Thank you so much, Dean Abrams, for that incredibly generous introduction, and also to Monica Roberson for all of her work in making this happen. And to all of you, of course, for coming today. It is a true honor to give the Robert R. Wilson Lecture, especially being a part of this very, very distinguished lineup of some of my favorite fellow historians, especially the great Thavolia Glimp, who's a shiro of mine. So you are one of the first groups that I've had the chance to share this new work with, and I deeply, deeply appreciate the opportunity for your thoughts. I'm hoping to have as much time as we can just to have conversations about some of what I'm gonna present today. Which is to think through a new theory of history that I've been developing, a new approach to archival methods, and a new approach to doing public history for social justice. It's a type of applied history that I want to systematize, and that's responsive to a growing interest in legal history. The last decade in particular has witnessed a tremendous expansion of JD PhD programs, as well as course offerings and workshops and seminars in legal history. So it's not surprising that historians have become more active participants in legal discourse and are increasingly contributing to Supreme Court amicus briefs and testifying before Congress. Historians signed only 6 Supreme Court amicus briefs between 1989 and 1999. That number has grown more than 7-fold over the last few decades, and judges in turn have expressed a desire for greater involvement from historians in the legal process, especially in cases where history and tradition is at issue. And I understand from Dean Abrams as well that the Duke Law Review is going to be hosting a special symposium on history and the law. This rise in legal history is also evidenced by the simultaneous rise in originalism. Because assessing original intent requires historical research and analysis, originalism, right, is fundamentally a historical project, though one that's often prone to what historian Alfred H. Kelly calls law office history, or the way that legal practitioners often cherry-pick historical evidence in order to achieve legal ends. So history can be essentially a legal modality, but I propose its application for different ends, and that is using historical methods to identify and challenge the racial discrimination that remains entrenched in American criminal and civil law. And this work and this approach is very much a logical extension of my work on federal crime control policy and the history of various criminal laws. So let me begin with this story with O.J. Simpson. O.J. Simpson's always a great place to begin. Of course, this was the trial of the century. It kind of unfolded for 10 months over 1994 and 1995. I was about 10 years old when the trial was aired nationally. And my childhood was very much shaped by this trial, just like in many ways the O.J. case and verdict defined this moment in U.S. history in the mid-90s. It really gripped the entire nation. Simpson spent between about $3 to $5 million a day to pay for his extraordinary legal team, maybe the most extraordinary legal team in history, with Barry Scheck, F. Lee Bailey, Johnny Cochran, Robert Shapiro, Alan Dershowitz, among many other legal superstars. Could talk about O.J. all day, and I welcome further discussion. But for our purposes, what's important is that this dream team of legal powerhouses were able to pinpoint the exact way that racism shaped their client's case through extensive evidence. So Detective Mark Furman, who was one of the lead detectives on the case, during the trial, about 13 hours of interviews with Furman came out that took place between 1985 and 1994. In these interviews, Furman was making all kinds of racist comments. Not all of them actually played in the court, but the public heard them. Earlier in the trial, Furman had testified that he had not used the N-word within the last 10 years, which when these tapes became public and when they played in the courtroom, proved to be perjured testimony. And so his recorded words, as well as his denial of using the N-word and being racist, was a major, major blow to the prosecution's case. It was enough in itself to cast a reasonable doubt. The defense were able to argue that he planted evidence, which was something that he implied that he did on the tapes. So that, coupled with the irregularities of the LAPD's investigation and the DNA evidence, which again the defense was able to really, really pore over. They watched dozens and dozens of hours of videos of the investigation of the crime scene. They combed over every piece of evidence. This exhaustive approach to the evidence rendered in some way, and what the defense presented to the jury, rendered the O.J. verdict correct, because the defense did cast a reasonable doubt. So what if everybody had this kind of level of investigation of the evidence, right? In many cases, perhaps in most cases, if a defense team were able to comb through all kinds of evidentiary sources, the point of racial discrimination could be discovered because the system itself is so steeped in racism and discrimination. Especially after the civil rights movement, as my work and the work of many others has attempted to demonstrate, the criminal legal system has really functioned as the engine of racial inequality in this country, and the striking racial disparities within the system cannot be denied. And yet, as I'm sure most, if not all of you well know, the Supreme Court has made it virtually impossible to prove racism. It's nearly impossible to show that a law is racist, and if laws have a disparate impact, this doesn't necessarily matter in the eyes of the court. So there remains one tiny, tiny way to do it, and that's with historical archives, with manuscript collections, with government documents, and with municipal archives. So first, let me give you a little bit of back history. For most of the 20th century, the Supreme Court relied upon statistical data that revealed stark patterns of racial disparity to conclude that laws violated the Equal Protection Clause of the 14th Amendment and therefore legally constituted racial discrimination. So through the Jim Crow era, the Supreme Court declared unconstitutional laws that revealed a stark pattern of discrimination. The 1886 case Yale v. Hopkins marked the first time that the court overturned such a law. And this is a slide showing a lower court ruling with an image of Yale's laundry. So Woe demonstrated that the city of San Francisco denied 200 permits to Chinese laundry businesses and that only one was approved by the city. Again, based on these statistics alone, the Supreme Court struck down the laundry permitting ordinance on equal protection grounds, holding that such a stark discriminatory impact bespoke a discriminatory purpose. So when you have statistics like that, it indicated that a law was racist and therefore must be overturned. Similarly, in the 1960 case Gamillion v. Lightfoot, the court relied on statistics to find a constitutional violation. In this redistricting case, the city of Tuskegee, Alabama, home, of course, to Booker T. Washington's Tuskegee Institute, had redrawn its municipal limits to remove 98% of Black voters from the city without removing a single white voter or resident. This image, which was used as part of the ruling, kind of gives you a sense of this crazy gerrymandering. So the green square, the entire map, is the voting district before the redistricting, when 79% of the population was Black. And then the 28-sided polygon is the redistricted area, a newly created district that was 100% white. Again, in response to just these stark statistical disparities, the Supreme Court noted that, quote, the legislation is solely concerned with segregating white and colored voters by fencing Negro citizens out of town so as to deprive them of their pre-existing municipal vote. In other words, as in Yale, the statistical evidence of discriminatory impact was so stark that it indicated on its own a discriminatory purpose in the redrawing of the city's limits. These rulings upheld the principle that, in a democracy, if a law is obviously producing such skewed results, if it's denying people equal protection and due process and therefore violates the constitutional rights of a particular group, it's not working and it should be overturned. This is surely the original intent of the 14th Amendment's drafters, including the great radical Republican abolitionist Congressman Thaddeus Stevens from the state of Vermont. And if I am an originalist, I'm definitely a Reconstruction Amendment originalist. Now, with the civil rights movement and the enactment of landmark civil rights legislation, a moment when the bounds of citizenship expanded and public racism was no longer acceptable, the Supreme Court shifted further away from the original intent of the 14th Amendment, even as the originalism movement began to gain momentum among right-wing circles. Under the standards the court established in a series of decisions in the 1970s, statistics alone were no longer sufficient to prove that a particular law is racially discriminatory. So today, in order to establish an equal protection violation, a person must show that a state actor intended to discriminate against them or purposefully discriminated against them, and that this intention directly caused a discriminatory result. So again, this evidentiary threshold makes proving intent seemingly impossible, particularly with policies enacted after the civil rights movement, since lawmakers learned to draft statutes that are facially neutral and to avoid outright racist commentary. So it is meant to be impossible to prove racism by government standards, at least. In a series of decisions in the mid-1970s, the court erected a formidable barrier to the 14th Amendment challenges, holding proof of discriminatory impact to be insufficient on its own, and holding it instead that, quote, proof of racially discriminatory intent or purpose is required to show a violation of the Equal Protection Clause. The first of these cases, Washington v. Davis, decided in 1976, involved a qualifying exam for police officers in Washington, D.C. The district court found no discriminatory intent in instituting the exam and held the black plaintiff's claim of that the violation of due process and equal protection failed. The Court of Appeals reversed, holding that, quote, lack of discriminatory intent in designing and administering the exam was irrelevant. The critical fact was rather that a far greater proportion of blacks, 4 times as many, failed the test than did whites. So numbers alone, that's what really mattered in the appeals case. The Supreme Court, with Justice Byron White writing for the majority, disagreed. It held that the sole focus on discriminatory impact of a policy, while mandated by Title VII of the Civil Rights Act of 1964, was an error when the plaintiff brought a constitutional claim. Now, Justice White, who's pictured sitting at the far left of the slide, was instrumental in the advancement of the Kennedy administration's civil rights agenda and played a critical role in several of these misguided decisions. The decisions Justice White wrote for the majority set forth a strict new standard for establishing an equal protection violation and then making proof of discrimination a near impossibility. Writing for the court, White stated, quote, our cases have not embraced the proposition that a law or other official act, without regard to whether it reflects a racially discriminatory purpose, is unconstitutionally solely because it has a racially disproportionate impact. So now the court's essentially saying just because a law produces stark racial disparities doesn't mean that the law is racist. The court expanded on Davis the following year in 1977 with its Village of Arlington Heights versus Metropolitan Housing Development Corporation, or Arlington Heights decision, a case involving a zoning ordinance. And this is the case that really matters for our purposes. The court, in an opinion by Justice Powell, recognized that, quote, determining whether invidious discriminatory purpose was a motivating factor demands a sensitive inquiry into such circumstantial and direct evidence of intent as may be available. While the impact of an official action may provide an important starting point to the analysis, unless the pattern were as stark as in Gamillion or Yick Wo, which the court noted would only happen in rare cases, courts must look to other evidence for proof of discriminatory intent, and that proof lies in the archives. The court suggested several evidentiary sources from which proof may be drawn, including the historical background of a decision, particularly if it reveals a series of official actions taken for invidious purposes, departures from normal procedural sequence, substantial departures, the legislative or administrative history, especially where there are contemporary statements by members of the decision-making body, minutes of its meetings, or reports. Now, this list did not purport to be exhaustive, but essentially this ruling recognizes archival material, government documents, and city records as the primary evidentiary sources that can be used to uncover discriminatory intent. These sources, often hidden from public view in the basement of a library or collecting dust somewhere in a storage facility, can provide deeper insight into the debates that led to an enactment of a given law and policymakers' awareness of its impact on a particular group of people. Although it has yet to be fully utilized, Arlington Heights demonstrates that the historical record is full of opportunities to combat racial discrimination and advance social justice through the law. Now, I kind of came to this work by happenstance. In January 2020, I was approached by Noam Bayal, a criminal defense attorney representing a 32-year-old black man named Kendall Johnson. Mr. Johnson grew up in the Bushwick Houses, a public housing project in Brooklyn where his parents still live. A drug conviction Mr. Johnson received in his early 20s prohibits him from living with them. This was part of the kind of Clinton era, one strike and you're out, really tough line policy or tough line set of policies that criminalized people in public housing. 6 months after the creation of this one strike and you're out policy in 1996, nearly 4,000 people were evicted from various housing projects across the country. After being released from New York State Prison without stable housing, a job, or economic prospects, Mr. Johnson quickly turned to what led to his incarceration in the first place, dealing drugs. On June 25th, 2019, Mr. Johnson agreed to sell less than a gram of cocaine base, commonly known as crack, and less than a half gram of heroin in the vicinity of the Bushwick houses to a buyer who turned out to be a confidential informant. Now, because Mr. Johnson had sold such a small quantity of drugs, his charge did not trigger a mandatory minimum sentence, but he had distributed narcotics within 1,000 feet of a housing project. This statute, USC 860A, is a relatively obscure provision of the Violent Crime Control and Law Enforcement Act of 1994, what I'll refer to as the 1994 Crime Bill moving forward. And let me actually just pause on this piece of legislation to put this statute in context. The 1994 Crime Bill, I'm sure many of you are familiar with. It's kind of known as being the legislation, the policy that really led to this skyrocketing of the prison system in the mid-1990s. The provisions of this bill included covering up to 75% of the cost of new prison construction. It also defined 60 new death-worthy offenses. It led many states to eliminate parole. It constricted incarcerated people's access to higher education by eliminating their eligibility for Pell Grants, while simultaneously implementing a GI Bill for police officers, which greatly expanded law enforcement officials' access to public education, or to education, higher education, which is always a good thing. But it's kind of ironic that at the same time this bill constricted incarcerated people's access to education, it enlarged law enforcement officials' access to education. It also introduced 100,000 new urban police officers on the streets of American cities, and it made it more difficult for individuals to file habeas corpus appeals, which destroyed a big layer of hope for people in prison at the prospect of coming home. The legislation pumped in total $10 billion for the expansion of police forces in the US and $10 billion for prison construction, what amounts to more than $40 billion in today's dollars of investment into policing and prisons and surveillance. The real crime, though, of the 1994 Crime Bill, as I see it, is that in the years leading up to its enactment, the Congressional Research Service had produced all of this data indicating that there was a severe racial inequality in the way that capital cases were being adjudicated, as well as raised serious issues and questions about the 100-to-1 powder cocaine and crack cocaine sentencing disparity. So Congress was very aware that the system was kind of producing these concerning racial inequalities, and instead of taking a moment to pause and reform some of these policies, Congress doubled down and invested tens of billions of dollars into that same system. Not surprisingly, national legislators ended up replicating and exacerbating these results through the legislation. And of course, the crime bill enacted new federal mandatory minimum criminal laws like the one that Mr. Johnson was charged with. This statute 860A instituted sentencing enhancements for narcotics distribution, quote, in or on or within 1,000 feet of a housing facility owned by a public housing authority. So this is a totally facially neutral statute, just kind of thrown in there on page 316 of a nearly 356-page piece of legislation. It's right next to a task force to address the problem of exotic plant smuggling from Hawaii. And this obscure little bill just thrown in there landed Mr. Johnson in Brooklyn's Metropolitan Detention Center and tens of thousands of other men and women of color over time. So firsthand experience as a criminal lawyer taught Mr. Bayal that those who received 868 charges in New York City in the decade prior to Mr. Johnson's arrest were almost exclusively Black and Latino, and his hunch ended up proving correct. Jumping ahead a little bit here, but this is data that we produced for the case using PACER, which is like kind of a federal system that federal defenders use that collects data on who is being adjudicated through the system. This is a comprehensive data set that we used through the 2000s, and our data revealed that Black and Latino people are 85% of defendants charged with narcotics offenses based on proximity to public housing projects. Without West Virginia, if we took the state of West Virginia out of that equation, West Virginia is pretty much the only state where white people live in public housing. That number goes to 93%. Now, of course, the discriminatory impact as evidenced by our data would not be enough to make an equal protection challenge. So following Arlington Heights, Mr. Bayal needed historical proof of intent or discriminatory purpose to mount his defense. So early into his work in Mr. Johnson's case, Mr. Bayal encountered my first book, From the War on Poverty to the War on Crime, The Making of Mass Incarceration in America, which Dean Abrams mentioned, which offers the first historical account of national crime control policies. I argue in that book that policymakers shared a set of racist assumptions that led them to target low-income communities of color for expanded policing, surveillance, and incarceration from the 1960s onward. With my advisee, Elizabeth Ross, a JD PhD student at Harvard, and Elizabeth is somewhere in this room. There she is. Hi, Elizabeth. We're out here doing archival research for one of our other cases, had to take advantage of the opportunity to be in the area. Elizabeth and I scour the archives and newly declassified files of the Clinton administration, the congressional record, legislative documents, and other government sources. We found key quotes from Senators Joe Biden, Bob Dole, Bill Bradley, and other sponsors of the legislation indicating that the 860A statute was designed to respond to race-based fears about public housing. So let me show you a little bit of the evidence that we used. This is Bill Bradley introducing this statute for the first time in 1991. Again, just like with a lot of crime policy, especially in the 90s, many of these initiatives were led by Democrats, led by liberals. Within the Arlington Heights framework, this would be considered legislative history. So here we have Bradley declaring on the Senate floor, quote, "Most of us hope and expect that we can keep our children safe and free from drugs at home. We do not need criminal penalties to declare our homes drug-free zones. But talk to parents who live in public housing projects. They do not have that confidence. They work hard against all odds to raise kids safe and sound in the middle of what sometimes are open-air drug markets full of violence." Now, this might not be the most direct piece of evidence, but it does set up this dichotomy between most of us, the implication being ordinary Americans, perhaps suburban Americans, perhaps members of Congress themselves, contrasted against people who live in public housing, the majority of whom are Black and Latino, and Bradley knows this, whose neighborhoods are classified as being full of violence. And just as a side note here with this language, these neighborhoods, of course, are also full of disinvestment and systemic neglect and high rates of unemployment and poverty, right? This is the cocktail for the informal economies and drug addiction that often accompany these conditions. So, Bradley could have also called into question why the response to these problems is always a punitive one. And then Bradley goes on to provide some really kind of strange logic to generate support for the new law, implying that drug dealers prefer to be in prison, quote, "where it is warm and cheap and they can stay in business," as if prison is somehow a goal. Okay, so here's Bradley again, it's not letting up, in 1993 on the Senate floor, touting the provision as the crime bill is being debated. And here, 2 years later, he's really giving us a kind of nightmare America scene. He says, "A child killed in a drive-by shooting, an elderly woman afraid to walk out of her home for fear of being robbed in broad daylight by some drugged-up young thug. A businessman driving in his car, the random victim of a carjacking," continuing to set up these dichotomies, very much implicitly invoking ideas about race and crime. And then he makes it plain. "We take quick glances behind ourselves and we take money out of ATM machines. We cross the street in an effort to avoid people that we think are threatening. Increasingly, the profile of a threatening person, at least as depicted by the media and suggested by their disproportionate presence in our prisons, are young Black and Hispanic men." Now, there are a lot of ways that last statement can be interpreted. Even if we're generous and say that Bradley himself didn't carry any racist associations between Blackness and criminality and was just commenting on the pervasiveness of this trope in American popular culture, the idea of a frightening, senseless, threatening young Black or Latino male was imbued in the very introduction of the legislation. And of course, Bradley's comments in 1991 become even more clear in light of his more blatant invocation of race in 1993. All right, so let me take you into some of the archives that we used in the Clinton administration. This memo from 1993, around the same time that Bradley's touting the provision on the Senate floor, links the Clinton administration to the crime bill. Arguing, Rahm Emanuel here is arguing that it should be called the Clinton crime bill and that the administration really needed to own the introduction of 100,000 new police officers in the cops office that was enacted as part of the crime bill. And indeed, the Clinton crime bill, right, is largely how the bill has come to be known, so much so that this legislation really came back to haunt Hillary Clinton during her presidential campaign in 2016. So because we were able to link the Clinton administration to the crafting of the bill's provisions, we used and cited newly declassified archival materials documenting Operation Safe Home, which was an influential Clinton administration program that brought additional federal law enforcement resources to public housing programs and criminalized tenants in the process. So this is a memo about Operation Safe Home, and here HUD is directly suggesting that the crime bill increased penalties to include public housing in the free zone school bill, which is of course exactly what it did. And then these 1996 campaign materials are also really telling. It's showing the way that officials framed Operation Safe Home as a program that was implemented to benefit Black communities and was kind of sold to Black constituents as a response of the Clinton administration to help Black people. So this document is about strengthening Black families. It states President Clinton is committed to ensuring that African Americans have the same opportunities to win as all Americans, and then it goes on to laud the administration's accomplishments on this front. In the Building on Our Progress section, the plan states that, quote, the administration is working to provide greater opportunities for African Americans by introducing Operation Safe Home to fight crime in public housing. So this really shows the way that high domestic policy officials urged specifically, right, and benefited from the implementation. So they urged that the statute be enacted as part of the crime bill, and then they kind of exploited its enactment to, adjudicate a range of sentencing enhancements that were part of the crime bill, and then that were linked to this advocacy and their work in Operation Safe Home. So these and other discoveries gave ample evidence demonstrating federal policymakers' full knowledge of the predictable effects of racial imbalance in the enactment of the sentencing enhancement and many other criminal statutes in the 1994 crime bill. So in addition to the archives that I just shared, which satisfied the legislative and the administrative history components, we included further historical background in our expert declaration. And this is a map of Brooklyn from 1938, this one on the left here, depicting the red line areas of Bed-Stuy, Bushwick, Canarsie, and Sunset Park. The other one is a map of where NYCHA, New York City Housing Authority buildings are located. And we see that nearly every single NYCHA building, the little black dots, right, is in a neighborhood with 80 to 90+% of people of color, right? Of course, extremely segregated public housing is not just a New York City phenomenon, it's a national phenomenon, but it underscores the way that public housing in this country is essentially synonymous with people of color, and that legislators had full knowledge of this fact. We also included one image. This is a campaign photo from March 1992, right before Super Tuesday, when Clinton visited the prison at Stone Mountain, Georgia, a city known, of course, for being the birthplace of the modern Klan. And it's kind of interesting to think about what Clinton is signaling here in light of where the MAGA movement has been today. In the speech, Clinton's literally promising, but the image itself promises to the American people that he will be tough on crime by locking up mostly Black men, a feat that was accomplished by the Clinton crime bill. All right, so we wrote all of this evidence up in a declaration that Mr. Bayal included in his motion to dismiss the mandatory minimum penalty. And rather than agree to allow the court to examine the racist history of the provision even further, the U.S. Attorney dropped the 860A charge, and Mr. Johnson was released for time served on August 20th, 2020. The timing was really important here because this case was adjudicated during COVID, and the virus was really raging that summer. So with Mr. Johnson's permission, we published our expert declaration as an article in the Harvard Law and Policy Review so that our work can be used to challenge similar charges in the future. Mr. Johnson's case really showed us the potential for historical research and analysis to illustrate the way that racism has shaped facially neutral laws, from mandatory minimum sentences like 860A to federal disenfranchisement, or to felony disenfranchisement. Since my collaboration with Mr. Bayal, I have gone on to partner with legal advocates on both criminal and civil matters, bringing Arlington Heights challenges to racial discriminatory laws. In April 2023, I assembled a team of JD PhD students, including Elizabeth Ross, as well as law students, doctoral students in history and African American studies, and undergraduates at Yale, Harvard, to join me in my collaboration with attorneys. And we call this the Challenging Racism in the Law Project. Last fall at Yale Law School, we held a symposium with many of the attorneys and federal defenders that we work with. And you know, the person in the middle with his arms crossed there, Professor Blocher, graced us with his presence. Hi, it's so good to see you. Thank you for coming. And actually, that's Elizabeth Ross right there next to him in the light tan blazer. And in the very back with a big smile is the amazing Caitlin Swain. I don't know if Caitlin's here. I don't think she's here. Duke Law grad and founding co-director of Forward Justice right here in Durham Raleigh, and her colleague Daryl Atkinson sitting next to her, among other legal scholars, law students, federal defenders. It was a really amazing day. We see this work as responding to a demonstrated hunger for legal history in courtrooms and law school courses, as well as an increased focus on public history in the academy. For me, it also fills a really crucial gap in graduate school curricula. I was never trained in how to use archives. It's kind of like you have to figure it out for yourself. And this allows us to engage in archival practices together as we interpret data collectively. It also is thoroughly interdisciplinary. It's not only people on the humanities and social sciences side, but also on the data sciences side, right? Because we have to do all the statistical work to prove disparate impact initially. And together we, prepare expert declarations like we did in Mr. Johnson's case, research memos, amicus briefs, and policy white papers. And most of the historical work, as I mentioned at the beginning, or the way that historians have participated in legal proceedings is through amicus briefs, but we see this much more as kind of like a curated, bespoke, more tailored approach that really does the research around individual cases, individual clients. The way that we operate is that our clients are attorneys and we serve their clients. And my aim is not only to help students gain vital skills to serve them for the rest of their careers, but also to apply this knowledge beyond the archive and the classroom and into the world where it has the potential to make even wider contributions. We have several very active projects that I'll run through, and I can get into more in the Q&A, but hopefully by the spring we don't have any active cases right now. We're continuing to do the research, and in the spring we expect that we will have a couple once we are able to review the legislative archive that we just spent a lot of time last summer and into the fall gathering. With the Federal Defender Office in the Eastern District of New York and in Connecticut, we're really focusing on gun laws, sentencing enhancements that carry additional penalties for offenses involving the possession or use of a firearm during the commission of a crime, so the 924Cs, but also other provisions within the 924 series. With the Eastern District, we're also working on material support for terrorism, 2339B, a statute that criminalizes providing material support for a group classified as a terrorist organization. The Eastern District was really interested in us working on this provision because in their office, most of the people that are being charged with this penalty are Muslims, especially Muslims of African descent. It's also, material support has been kind of increasingly an issue with student protests across the country, especially last spring, where even many faculty were concerned that charges could be brought against them for doing things like bringing students water. Within the Federal Defender Office in the Eastern District of Virginia, we're examining 21 U.S.C. 841A1, which criminalizes possession of marijuana with intent to distribute. Marijuana, of course, is still illegal federally, and in a number of states, especially in the southern states, it's used especially against defendants of color. We're also working with the Eastern District of Virginia on the Armed Career Criminal Act of 1984, which is essentially like anti-gang legislation that in many ways comes out of some of the research that I did in my first book when the kind of antecedents to that law were being debated and conceived in the 1970s. And we're working on a challenge to the Fair Sentencing Act of 2010, which perpetuated a racially discriminatory sentencing disparity between crack and powder cocaine. This is actually the subject of my third book project, which is entitled Criminal Injustice, Crack Cocaine Laws and Their Legacies, under contract with Norton. And this book will cover much of the material that our case will draw upon, and I'm happy to talk about that further in the Q&A. We're actually doing this work on the Fair Sentencing Act with Raleigh Durham's own Forward Justice, which also happens to be the kind of poster child for Arlington Heights challenges. As I mentioned, Daryl Atkinson and Caitlin Swain represent Forward Justice along with their fellow co-founder, Dr. Ashley Marshall, who's not here. All three, I'm sure some of you are familiar with their work since they're local, but they are just incredible humans, brilliant thinkers and organizers, and truly innovative movement leaders for the 21st century. Daryl and Caitlin actually argued the case where they used the Arlington Heights framework. This is Daryl presenting closing argument. And so as part of this case, in November 2019, Forward Justice was among the parties who filed a lawsuit on behalf of the North Carolina NAACP and other civil rights organizations and a handful of individuals seeking to reinstate voting rights for tens of thousands of North Carolinians previously convicted of felonies who had their right to vote taken away under the state's felony disenfranchisement law. So Forward Justice and their partners argued in a case called Community Success Initiative, or CSI v. Moore, that barring people with convictions from the right to vote violated several provisions of the North Carolina Constitution: the Free Elections Clause, the Equal Protection Clause, freedom of speech and assembly, and the ban on property qualifications. On Monday, March 28, 2022, a 3-judge panel granted any individual on probation, parole, or post-release supervision immediately eligible to register to vote. Their historic judgment, the ruling was titled, "The History and Intent of NCGS 13-1 are rooted in racial discrimination against African-American people and suppression of African-American political power," immediately restored voting rights to over 55,000 North Carolinians on probation, parole, or post-release supervision, making it the greatest expansion of voting rights in North Carolina history since the 1965 Voting Rights Act. The Department of Justice actually uses CSI v. Moore as kind of a case study of how to do a successful Arlington Heights challenge. It's truly remarkable. I think it made a slight difference, at least in the 2022 midterms. Obviously, not everyone whose vote was restored voted, but we know at least 15,000 people did. Unfortunately, just over a year later, the new North Carolina Supreme Court, in a 5-2 decision split along partisan and racial lines, stole these voting rights back from this nearly 55,000 North Carolinians and reinstated the state's racist felony disenfranchisement laws, including a requirement to pay money to regain the right to vote. And of course, this is very disappointing, but it doesn't deter us. This is exactly why we do this work. We keep fighting and not get discouraged. Now, it's unclear, I'm just about to wrap up here, it's unclear what courts are really going to do with Arlington Heights challenges moving forward. The place where we're actually seeing the most use of the Arlington Heights framework is on a statute called 1326, which criminalizes unauthorized entry into the United States after a previous deportation. So similar to the work that we did on the Kendall Johnson case, the historian of the border and of criminalization in Los Angeles, Kelly Lytle Hernandez, worked to help produce a declaration relying largely on the congressional record and government reports to show that policymakers targeted individuals from Central and South America when they enacted and amended this law in the 1920s and 1950s. A district court judge in Nevada agreed that the law was discriminatory, and then in May 2023, so like just as I was getting my own research team off the ground, the Ninth Circuit reversed this decision, arguing in part that Arlington Heights doesn't apply to immigration law. And again, this is a disappointment, but not a deterrent. I think it's been really clarifying for me and my team in terms of the level of evidentiary proof it takes to successfully take down these things. I don't know, to be honest, if we had an opportunity to go back and do the Kendall Johnson case again, we've learned a lot. We do things a lot differently. But in that, in the Creel-Lopez ruling, when the Ninth Circuit overturned, they stated that you can't just have a few comments from a few Congress people. You need to show how these views, these discriminatory views, pervaded Congress. You need statements that can be really as explicit as possible. So definitely, again, alone that when Bradley introduced the public housing statute in 1991, that would not have worked. You can't get too theoretical also in explaining why certain ideas and theories are racist. The good thing about the 1326 work is that Kelly's declaration has been reproduced and shared by the San Diego Office of Federal Defenders. So other federal defenders are continuing to do these 1326 cases, and a really important one was argued last fall before the Second District by Erwin Sherminsky. The Ninth Circuit's decision also means that we are close to one of these Arlington Heights challenges, possibly reaching the Supreme Court. If another circuit court accepts an Arlington Heights challenge, the Supreme Court could hear the case to resolve the future of this provision, and it's very likely that the current court would overturn Arlington Heights. But even if that happens, I am hoping that we create a new and hopefully enduring role for history and historical research to take more significant roles in civil and criminal cases. I think history can be a really important tool for lawyers. We're working, we've done things like train the ACLU in historical research methods on many of the Racial Justice Act cases that they're currently working on in the state of California. One of the kind of co-founders of the clinic, another JD PhD student of mine, Elsa Hardy, was working for Miriam Gahara's challenging mass incarceration clinic at Yale Law School and used her own archival methods, brought that to the clinic, and was actually able to meaningfully discover the birthplace of one of their clients' mothers that had a humongous impact on the client. And this work, not being deterred by this work, is very much in the spirit of one of my late mentors, the Pulitzer Prize winning historian Manning Marable, who taught me that history is a weapon with which we fight. Now, not everyone agrees to that approach to history, but that is my approach. I think that history can and should be a tool and a weapon for social justice and social change. So the dream of this work, right, is for major policy transformation, for these laws to get overturned. But success is what we got in the Kendall Johnson case, getting people more humane sentences and setting people free. So as much as I hope that this work will result in major policy changes, perhaps more importantly, it has the potential to have a meaningful impact on the lives of individuals like Mr. Johnson, their families, and their communities who have been subject to racially discriminatory sentencing for generations. I'll end there. Thank you. And I'm really happy to take questions, comments, ideas. Is that a hand? Don't be shy. Hi.
Thank you. That was wonderful. You kind of alluded to it a little bit at the end, and some of these more potentially hostile circuits and how difficult they're even taking the Arlington Heights standards and requiring explicit affirmation,
Yeah.
and they're not willing to, even if it's the bill's author,
Yeah.
excuse me, extrapolate that into the intent of the bill. And so, like, I'm also just thinking specifically about, there was a case in Alabama a few years ago. Their felony disenfranchisement law was in their constitution from 1900. The court overturned it, and then the next year they just repassed it with the same language.
Same thing that happened here, right?
Right, the exact same.
What they're doing with you see it in Florida too. They're really kind of doubling down back on any gains in that arena, but yeah.
So I was just kind of curious, though, given that, if you have any kind of thoughts or advice about how you approach that, how you would then change your briefing accordingly.
Yeah.
Just any kind of thoughts or guidance.
Yeah, so, again, thinking back to the OJ strategy, one of the things that we've been doing is trying to look through as many, so it's a legislative history, but for the marijuana case that we were working on, for example, we started trying to look through all of the manuscript collections of all of the major sponsors of the bill. Really trying, again, it's exhaustive research, right? Trying to find as much information as we can from key players. In that case, one of the really, because that case involves the Controlled Substances Act of 1970, and one of the really kind of powerful pieces of evidence that we have there is it's a partisan vote. So all of the congressmen who voted, congresspeople who voted for the Controlled Substances Act also voted, mostly Southern Democrats and Northern Republicans, also voted against the Civil Rights Act. So those and many of them signed the Southern Manifesto. So when you have evidence like that, that gives you a kind of larger mindset of a large swath of people. But it really is, when that Carrillo-Lopez decision came out in May 2023, we tried to use it as a roadblock for the level of archival research that we'd have to do for these cases, which is extensive, right? So I think part of it is just kind of recalibrating, thinking how we can be as thorough as possible to mount successful challenges. And I think writing within the Arlington Heights framework or doing research within the Arlington Heights framework has made me a more careful and thorough historian, and even more careful and thorough historian, because when you write these things, they really become little case studies of systemic racism. I think part of the hope is, and a lot of the attorneys that we're working with see this, if nothing else, as a way to really help with sentencing. So, I in the past few years, my research, especially my work with data scientists, has further convinced me just the way that sentencing itself and disparate sentencing practices are such a key driver, if not the key driver, of racial inequities. So I'm also kind of thrilled to do this work in the sense that if we can get a small army of people doing this research to get people better sentences, that in turn can make a huge, maybe again, micro, small, but eventually larger impact on the problem of mass incarceration in this country. Yes, sir.
I wonder if you might like to talk about the interaction of the news media's treatment of crime and the public opinion polls that showed during the late 80s, early 90s, that crime was people's #1 concern, even if they weren't personally experiencing it, and how that played into the passage of some of this legislation. And my recollection is basically the Democrats gave up trying to oppose this kind of legislation and moved over to more support for it. And I just don't know how that plays into the story as you understand it, and what you have to find in the archives, or how we understand what really happened.
That's a great question. I think one of the things that certainly in my first book I really tried to show, because the first major kind of federal sentencing policy, the Omnibus Crime Control and Safe Streets Act, right? We get at the height of progressive social change in the civil rights revolution. It's a Johnson policy. The two kind of great architects of the criminal system and mass incarceration and policing as we know it today are Lyndon Johnson and Bill Clinton, because they, under their administrations and with their active involvement in, these landmark pieces of congressional legislation, taxpayers, Congress invested taxpayers' money into policing and surveillance and locking people up. So one of the things, is that I think Democrats have always been on board for these policies that really, like, crime control policies have been the only domestic policy issue in the last half century or so that Republicans and Democrats agreed upon. I think, with the crime bill debates, I mean, certainly the Congressional Black Caucus and other kind of liberal Democrats were really trying to get as much prevention funding and kind of social welfare programs as they could out of the legislation. One of the things I show in my first book, too, is this transition that really begins in the 70s where, funding for public programs, especially in low-income communities of color, is impossible to get outside of the criminal system. So by the 90s, many of these liberal Democrats are in this position where the only way they can get, from midnight basketball to, after-school programs for their constituents is through the crime bill. But certainly, I think the kind of the links, the trope of Black in particular criminality is something that's animated all of U.S. history. Certainly, I think in the 80s and 90s, there's increasing coverage and sensationalized and racialized coverage in the media as Reagan's war on drugs and then Clinton's continuation of the war on drugs and the war on gangs, super predators is unfolding. So it's very easy for someone like Bradley to be able to invoke that. When I was reading that back, I remember, people used to always talk about walking to the other side of the street when certain people are there clutching your purse in the elevator. That's not as much part of our discourse anymore, but I think, the media, the American obsession with crime and, the, sensationalized crime in the nightly news, the feeling that, especially in the 90s when violent crime is going down, the continued feeling that the media kind of continues to perpetuate that even if you're, living in a safe suburban neighborhood, that crime could be all around the corner anytime, that everyone's unsafe, even though we know that most victims of violent crimes are people that people know in their communities. It's not something that's necessarily spreading everywhere. But that idea, that perception is what then is used or exploited to generate widespread support for these policies that, in a lot of ways don't make sense. Again, I posed it when I was discussing Bradley's comment, but why respond to that picture of public housing that he depicted? Why is it that more punitive programs imposing this mandatory minimum sentence is the solution to that, rather than getting people drug treatment, rather than improving the conditions in public housing? So yeah, that's what I would say. I saw you had your hand up, yeah.
So I have your first book as a physical copy. I've got your second, an audio book. I didn't know you were doing a third. You mentioned it. Can you share a bit more about it?
Yeah, so I'm really excited about that book. It's about federal crack cocaine laws. So it's not about crack itself, it's about the debates that emerged about the 100-to-1 sentencing disparity that was enacted as part of the Anti-Drug Abuse Act of 1986. And this was a kind of project that I kind of came about. My first project, I had more intention about what I was looking for in the archives. I was just in the Clinton archive, actually, with Elizabeth Ross and some of my other advisees. Elizabeth and my other advisees were all kind of working on Clinton's crime policies. I had never, in my first book, been to the Clinton archive, and I wanted to kind of see, for another project I was working on, what was in there. I didn't touch the 94 crime bill, which is kind of the big kahuna, as I've been saying. And I saw all these debates that were happening in the 90s about the crack cocaine sentencing disparity. There was a real there was a recognition that the law had no pharmacological basis whatsoever, that it was enacted in haste. Again, I mentioned that the Congressional Research Service in 1991, 1992 were aware of the real disparities in sentencing around these laws. And by the mid-90s, in nearly every major city, it came to policymakers' attention that literally for the federal crack cocaine mandatory minimum penalties, it was really only Black people were charged with the federal offense. So, like a white even though the majority of people who used crack were white. So a white person adjudicated at the state level would get like a year probation, and a black person with federal charges would get 5 to 10 years. There was all this awareness about this then, and I was just in the archive with my jaw just hitting the floor. And I thought then, I said, wow, like this evidence, like this actually, because this law, even though it was, changed from 101 to 18 to 1 in 2010, there should be no disparity whatsoever. That's what many people were advocating for, even the Clinton administration. And I will say I was shocked to discover that Clinton himself in the archive, wanted parity. He personally supported parity, which shocked me. And that, despite policymakers' awareness of this, generations of people are still incarcerated under this law. Now, President Biden, in one of his last-minute commutation, released about half of the people. There are about 6,000 people, a little less than half, 6,000 people, 90+% of them black, who are still serving federal crack crimes in the federal system. But we think about, what is the impact of this benign neglect on the part of policymakers? And so it's about the crack sentencing laws, but really, again, these questions about sentencing in this country in general, and a real case study, a powerful case study in how systemic racism works with a really tight set of historical archives. So I'm really excited for this book. I get to write about the 90s, I get to write about OJ, which I haven't gotten to do before.
Well, on that note, we are out of time.
Thank you so much for coming. Thanks for bearing with my voice, too. I'm glad I made it through the talk.
Maybe Professor Hinton can stick around for
I would be-
some more casual conversation.
I would be happy to, as long as we can stay in the room. Thank you. Oh, good. Oh.